Very good evening to you all. Welcome you all to the virtual program on CA's role in PMLA. Let us please stay for a motto song.
य एष सुप्तेषु जागृति य एष सुप्तेषु जागृति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्वैता 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 एतद्वैता
Please stay for a UFA video.
Arthashastram, Dharmashastram cha, meaning economic principles Arth and ethical considerations Dharma, which are central to the work of accountants. The entire world is deliberating about impact of climate change coupled with disruptions of artificial intelligence. India has given philosophy of Vasudhaiva Kutumbakam to the world and successfully hosted G20 summit on this theme and also launched Global Biofuels Alliance. The accounting profession also has an enormous responsibility to guide the world, where accountability meets innovation so that vision can be converted into solution. The Institute of Chartered Accountants of India, being the world's largest accounting body after the successful hosting of WCOA 2022 and GLOPAC, proudly presents before the World Forum of Accountants 2025. Where accountability meets innovation for a sustainable planet. The world's brightest minds will exchange insights, explore emerging trends, and unlock the possibilities for the profession, where foundation will be laid to shape the vision for the future of accounting profession. Hosted at Yashobhoomi, the largest convention and exhibition center in the heart of India's capital, New Delhi, inaugurated by the Honorable Prime Minister Shri Narendra Modi, is all set to host the congregation of accountants from around the world. And while you're here, experience the vibrant culture and heritage of New Delhi, a city where history meets modernity, offering unforgettable memories.
World Forum of Accountants, an experience of 3 days, insightful discussion, groundbreaking innovations and unparalleled networking opportunities.
With immense pride, we invite you to WOFA 2025, taking place, happening from January 31st to February 2nd, 2025 at the magnificent Yashobhoomi, New Delhi. Experience 3 days of insightful discussions, groundbreaking innovations and unparalleled networking opportunities. World Forum of Accountants 2025 is where you need to be, where accountability meets innovation, AI for a sustainable planet. Join us at WOFA 2025 from January 31st to February 2nd, 2025 at Yashobhoomi, New Delhi. For more details, visit wofa.icai.org.
Let me introduce today's speaker, Sankalp Malik, advocate. Advocate Sankalp Malik is a practicing in the field of direct tax and economic law litigation. He is the partner at Malik & Co. Advisors and advocates since 1927. Mr. Sankalp Malik regularly appears before authorities such as the ITAT, ATFP, NCLT, HUTSIS, Pan India, and the Supreme Court. He is an alumnus of Amity Law School, Noida, during the period of which he won various national, international mock trial competitions, and also worked with various known personalities in the legal profession in the field of criminal, tax, and economics laws. Sankalp Malik has several reported judgments under the Income Tax Act, Binamila, PMLA, Black Money Act from the tribunals, High Court, and the Supreme Court of India, and heads the litigation division of Malik & Co. He also writes research papers which are published in journals of great repute such as Taxman and Chambers of Tax Consultants. With this short introduction, SIRC of ICI welcomes Advocate Sankalp Malik to this knowledge sharing session. Welcome, sir.
Thank you so much, Ratnavel sir. It's an absolute pleasure and honor for me to be here and deliberate today on this highly vexed topic, which we all have heard about, which is the Prevention of Money Laundering Act. I think if we go back 7 or 8 years ago, hardly there was anybody in this country who would be aware of what ED is. We used to fear agencies like CBI. And CBI was the biggest goon, if I may say that term in a very loose manner. But in the last 5, 6, 7 years, we have seen, especially since 2014, we have seen that the ED has been made highly powerful, given a lot of steps. Their powers are not even curtailed by the courts to an extent that they even become arbitrary. And this is my own limited opinion. So it becomes highly important for us to understand the concept of the Money Laundering Act, how and around what areas and domains does the PMLA work and have its interplay. And most importantly, I was asked to also show and demonstrate and deliberate as to what is the role of a CA in PMLA proceedings. So, without further ado, sir, I would like to share my screen if possible. And is my screen visible, sir? Hello?
It is. Yeah, you can share it, sir.
Yeah, just a second.
Yeah, it is visible.
Just a second. Yeah. So it is an act, though a very small act, but a very complex act, if I may say so. We will be discussing about the introduction. How did PMLA come into India? What was the need of enacting the law of PMLA? Then, after its enactment, what is money laundering? What are the key provisions of the act? What are the compliance and reporting obligations? And the challenges, emerging trends, best practices, and recommendations as how to go about PMLA if we are stuck in it or if any of our clients are stuck in it. I said two things: when we are stuck in it and when our clients are stuck in it. Number two, as lawyers, I only find clients being stuck with it. Seldomly, I have come across a situation where a professional is bought into the garb of PMLA. But CAs, we hear a lot of CAs being arrested by the ED in connection to an offense under the PMLA. So, when I said when we are entangled and engrossed in PMLA, is that situation. And the second situation is when we have to tell a client. For both these things, we need to understand how and why was a need to bring in a law to cover money laundering specifically. So I take you back to the year 1970s when in Vienna Convention, for the very first time, the definition of money laundering was enacted in Article 3.1. But as far as the Vienna Convention was concerned, it was concerned and it was limited to predicate offenses relating to drug trafficking and human trafficking and extreme grave offenses. Rather, Vienna Convention, then later on in the Palermo Convention, FATF recommended other countries to join, and India, being a member of all these conventions, also enacted the PMLA. But before I move further, we need to understand why was PMLA brought into those foreign treaties and foreign conventions. Those we have all heard about Pablo Escobar. Haven't we? I would like a response from everybody so that it becomes more of an interactive session. You all can comment, and if you have any queries, you can note it down and we can take all the queries one by one at the end. So, what Pablo Escobar and Che Guevara and other big drug traffickers at that point of time in the year 1970s, 80s did, they used to set up saloons. And in those saloons, they used to just make fake billing and convert all their drug money into white money and show that and put that as clear untaxed money, a clear legitimate money, and even pay tax on it, so that the money is placed, it is led in the system by making bills and integrated into the system after paying tax as clean money from business. So money laundering is buying or getting money from predicate offenses or scheduled offenses, and whatever money is derived from such scheduled offenses is the proceeds of crime. I will delve more deeper into proceeds of crime in a few slides, but just for your reference, proceeds of crime is the very fundamental aspect of PMLA. The entire PMLA revolves around proceeds of crime. So, because of these conventions, PMLA was enacted. Who is the authority under this act? We are very well aware that it is the ED who undertakes all these actions. ED has been defined, authorities have been defined under Section 48 of the Prevention of Money Laundering Act, which includes the ED. ED has officers in the rank of director, additional and joint director, deputy director, assistant director, and such other classes of officers as appointed by the for the purposes of this act. And there is one more authority which is rather an information system for the government and even for all the other organizations, which is the Financial Intelligence Unit of India, which is called the FIU. So FIU comes under the Department of Revenue, Ministry of Finance, and it is the central most agency for receiving, processing, analyzing, disseminating information relating to suspected financial transactions and enforcement agencies. Now, this FIU is not only limited to the ED, it goes further, it goes way beyond. It goes to the Income Tax Act, it even informs the GST, it informs FEMA, it informs RBI. It is rather the most central most organization for information. Now, what is money laundering in ordinary parlance? Like I gave you that example, drug money received by selling drugs. Now we have drug money. We put that drug money into a saloon, showing it as bills. That is called placement. That we have placed it in a money. Now, after placing that money into the bank account of the saloon, we pay taxes on it and we layer it. From there, we send it to 1, 2, 3, buy different assets, buy FDs, book FDs, do anything under the sun. That is layering. And when we hide the pay taxes on that and show that money as genuine money from profession and business, it becomes integration. Now, after integrating and paying tax, the ultimate beneficiary, the drug lord or the crime lord, whoever's committing that scheduled offense, being the beneficial owner, then uses it as clean money. So that in ordinary parlance is money laundering. Now, the present act, PMLA, is called the Prevention of Money Laundering Act 2002. It has 10 chapters which are divided into total of 75 sections, and there are 3 schedules. There is one schedule having 3 parts. Now, if we break the act, we can see that section 1 and 2 forms under chapter 1, which has all the short titles and the commencement and the definition clauses. We will delve into the more important definitions in just a while. Section 3 and Section 4 form part of Chapter 2 of the Act, which is the offense of money laundering and its punishment. This is the deterrent so that we can deter and prevent money laundering by prohibiting any such action. So that prohibition and its punishment to do the prohibited act is given under Section 3 and 4. Now, from Section 5 to 11 is the attachment of property, is its adjudication, and its confiscation. This is the civil part. In PMLA, your property will also get attached and you will also suffer criminal prosecution. So it has both limbs, the civil limb as well as the criminal limb. The civil limb of attachment is given under Chapter 3 from Section 5 to 11. Chapter 4, which is from Section 11A to 15, are the obligations of banking companies, financial institutions, and intermediaries to give information to the ED. Because these banking corporations are under the helm of it. पैसा कहीं लॉन्डर होता है, ड्रग मनी कहीं से लॉन्डर हो रहा है, फॉरेन इन्वेस्टमेंट के नाम पे पैसा आ रहा है, बट दैट इज ड्रग मनी टू give effect to terrorist activities. All those transactions first would be known by the banking authority because they have to today know their customer, know what is the source, where is the money coming from, etc., etc. As the RBI impositions have been created by RBI. So those obligations of banking companies are also extended to the PMLA and to ED as these authorities become reporting entities. I will also tell you how chartered accountants are reporting entities under the PMLA, but I will come to that in a little later. Now, Chapter 5, which is from Section 16 to 24, covers the summons. आपको समन भेजा जा सकता है, आपके ऊपर सर्च करी जा सकती है, and seizures can be done during that search. All those powers have been given in chapter 5 from section 16 to 24. Now there is an appellate tribunal which is placed, and the appeal mechanism is there for the civil cases. So your appeal mechanism from adjudicating authority to the tribunal, to the High Court, to the Supreme Court, etc., is given from section 25 to 62. This is regarding the civil side of your attachment. Your criminal side, your criminal case will be dealt by a special court. That special court and its rights, powers, procedures, etc., are given in chapter 7 from section 43 to 47. Authorities under the PMLA are from section 48 to 57. And even like we started, that PMLA is not only an Indian law, it is a law where the entire nations of the world are together, where they give information regarding different transactions and such big activities to each other countries. Those reciprocal arrangements qua information with the foreign countries are given in chapter 9 from section 55 to 61. Going further, coming to the PMLA now, only and only to the PMLA and its parliamentary history of the law in India. The PMLA was passed by both the houses in January 2003, but the said act was made applicable with effect only from 2005, when a notification dated 1st of July 2015 was issued. So the act, though mentions PMLA 2002, it has been in existence since 2005. The first amendment in this act was created in 2009, second in 2012, third in 17, fourth in 18, 19, and so on. And rather, since the third amendment, since 2017, the ED has become very active. And the biggest amendments under the law have been done in the fourth, fifth, and later on amendments which have been done post 2017. So, what are the important principles under the PMLA? Number one, before we come into the law and come into the sections, let's understand what are the important principles of PMLA under the Act. Now, PMLA starts where the original criminal law stops. Why do I say this? I say this because PMLA is a piggybacking law. मतलब वो नॉर्मल क्रिमिनल लॉ के कंधे पे बैठ के आगे चलता है. मतलब एक क्रिमिनल लॉ, एक क्रिमिनल एक्शन, a criminal offense regarding a criminal law which is a scheduled offense under the PMLA should be done, number one. So when in, let's say, section 420, which is cheating, I take 1500 crores from the bank for a specific purpose. I don't put that money in that purpose. I divert that money for some other purposes. मेरे ऊपर 420 का केस लग जाएगा. 420 IPC, which now is section 500 something of the BNSS, is a scheduled offense under the PMLA. So 420 is separate. But because 420 is a scheduled offense, the 1500 crore rupees will become the proceeds of crime. Criminal law, criminal prosecution for 420 will keep going on. But in that FIR, that 1500 amount will also be liable to be attached under the PMLA separately. A separate criminal prosecution under the PMLA will also go against you in furtherance of the normal 420 prosecution. So there will be a 420 prosecution. There will be a attachment of money, of your assets, and there will be a criminal prosecution. So there will be 3 steps. Criminal prosecution under the PMLA. So till here, I hope you all are with me. The objective of PMLA is to confiscate and recover the ill-gotten money and the proceeds of crime. Now, proceeds of crime is a very tangible concept. If I explain proceeds of crime, you take this white paper, you dip an ant in red ink and let the ant walk anywhere on this white paper. Let's say it walks to A, person A, then goes to point B, then goes to point C, then goes to point D. So proceeds of crime has gone from A to B to C to D. Today, though money laundering and the schedule offense may have been committed by A, attachment can be done in the hands of D because the money has gone there. So a person who may not even be directly involved in the scheduled offense but has assisted in obtaining the ill-gotten money or assisted in transferring it, laundering it, concealing it, or even is in possession of the said proceeds of crime may be roped in under the proceedings under the PMLA. Now, this is precisely why PMLA becomes very dangerous. Now, coming to the definitions. What is proceeds of crime? Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense or the value of such property, or where such property is taken or held outside, then the property equivalent in value. So there are 3 limbs. Proceeds of crime means a property obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense. This is the first limb. I commit cheating. I take a loan of 1,000 crores from the bank. I buy a castle of 1,000 crores from that same money. You can identify that proceeds of crime has been used directly to buy this castle. So this castle directly can be attached. But what if I squander that money? Then the second limb comes in. Second limb starts after this or the value of any such property. Matlab, 1,500 crores was the value of such property, such proceeds of crime. Now, that same 1,500 crores in different properties which I may own can be attached. My properties which I may have purchased prior to even taking the loan from the bank can be attached. Now there is another third limb. The third limb is when you take the money abroad or where such property is taken or held outside the country, then the property equivalent in value held within the country. Property means any property, movable, immovable, incorporeal, corporeal, tangible, intangible, any asset and any instrument, even evidencing title to you. Now, value is 21ZB. Let's say I buy a house in 1980 for a sum of, let's say, 10 lakh rupees. The value of that property today is 10 crores. What would be the value of attachment? If they say I have proceeds of crime to 1 crore, which they can't find, and they now want to attach this property of mine, at what value would they attach the property? 21ZB says means the fair market value of the property on the date of its acquisition. So proceeds of crime was 1 crore. my property, which is today worth 10 crores, will be attached only for a value of 10 lakh rupees. And they will say that we still have to recover 90 lakhs more. I repeat, your property worth 10 crores, which you acquired for 10 lakh rupees, will be attached at a value of 10 lakh rupees, and they will still ask you for 90 lakhs more and will make further attachments of different assets. This provision makes the act extremely draconian. Now, coming to the elephant in the room, what is money laundering? Money laundering, as I mentioned earlier, has been defined under Section 3. It reads, whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession. Now, this is very important, possession, acquisition or use, and projecting or claiming it as untainted property shall be guilty of offense of money laundering. Now that means you read this, or whoever directly or indirectly, blah blah blah, or whosoever is actually involved in any process or activity connecting with the proceeds of crime, including its possession. So today, I take some money from, let's say, Mr. X as a loan. Mr. X is my friend. I ask him for a loan of 50 lakh rupees. He gives me that 50 lakh rupees. Out of that 50, I even return 10 lakh rupees to him. Right? A year later, ED comes. ED says Mr. X has committed scheduled offense. He has generated proceeds of crime. Those proceeds of crime have come to you. They are in your possession. And therefore, Mr. Sankalp, I am attaching your asset at a value of 50 lakh rupees. So, Section 3 and the word possession and its definition as has been adopted by the court, especially by the Supreme Court in the case of Vijay Madanlal Chaudhary, has made the act and its use even far more draconian than it actually was even put in the act. We take arguments in this section while arguing these cases day in, day out, that you have to see that process should be connected with the proceeds of crime. That process should have a direct or indirect connection where I am indulging directly or indirectly, and I am assisting knowingly, and I am knowingly a party to it. Therefore, only then can I be made a part of money laundering. But, sir, they are saying for the purposes of attachment, any person's property can be attached. So, even if we do not criminally prosecute you, your property can be attached. That is the definition of money laundering under Section 3. But what happens when you are found guilty of money laundering? Let's say I take a loan from bank, same example, 1500 crores. I don't tell Mr. A where the money has come from, I give it to him. I tell him, sir, you buy a lot of shares or you invest all that amount in mutual funds and give me a 15% return on it. Any return over and above that is your money. 15% you have to give me the money every year. And he says yes. He doesn't know that this money is from drug money or any scheduled offense. Then what happens? Then at least let's not go to Mr. X. My case starts and they find me guilty of money laundering. Then what will happen? I will be punished for money laundering as per Section 4. And the punishment is not rigorous imprisonment of not less than 3 years, which may extend to 7 years. And if it is regarding para 2 of Schedule A, this 7 years may be read as 10 years. So you, in a case of PMLA, and if you do a crime schedule offense of over 1 crores, which is a part of Schedule A, you will see rigorous imprisonment for a period between 3 to 10 years. That is the graveness of this act. Now, like I mentioned earlier, there are two types of proceedings under the PMLA. One is a civil proceeding, the other is a criminal proceeding. The civil proceeding is attachment and confiscation of that property. Now, attachment of property is undertaken by the ED under Section 5 of the Act. The purpose of that attachment is to only protect the interest of the ED so that that property cannot be transferred, cannot be alienated, no encumbrance can be created on that said property. And as and when the special court finally finds me guilty of money laundering, that asset can be confiscated. So civil consequences of attachment are subject to only protecting the interest of the ED. Now, I am 100% sure we have a lot many senior chartered accountants and people practicing in the field of income tax GST. One may note that under income tax GST, other proceedings such as the disciplinary proceedings, any proceeding, you first get a show cause notice, you give your reply, you get like even in an income tax assessment, you get notices, you file your replies, and then assessment is concluded by an order. Under PMLA, attachment is not subject to any proceedings. You will not be given any show cause notice. ED has the power to directly make attachment even without summoning, without calling you. So you may one fine day, wake up in the morning, say it's a very beautiful morning, but by 12 o'clock, there can be possibilities that you would be served with a provisional attachment order of your property, saying that you had used a certain money which came from so and so, and that money was proceeds of crime generated from a scheduled offense, and therefore, because that money came to you, we are attaching your asset. So your very good morning will turn into a very bad morning without even giving you an opportunity of being heard. So that attachment happens under Section 5. Now, after that, what happens? After Section 5's attachment, the ED, the deputy director, the assistant director, as the case may be, has to file a complaint, which is like we file an appeal before the commissioner appeals in income tax and GST. The ED themselves file a complaint before the adjudicating authority stating ki I have made this attachment. Now you may decide whether to continue that attachment or not. And this attachment is only valid for a period of 180 days. And during those 180 days, the adjudicating authority decides as to whether that attachment is liable to be confirmed or not. So, first step is attachment. Second step is ED files a complaint to the adjudicating authority. Third, adjudicating authority will record its reasons and issue show cause notice to you. Your proceedings will go on, and before the 180 day expires, you will receive an order from the adjudicating authority confirming or revoking the attachments. But on a practical standpoint, after doing about more than 200 cases of attachment and criminal prosecution under the PMLA, and also working from the side of the ED before the High Court and the Supreme Court, I can say that only seldomly adjudicating authority leaves an attachment. Even if a case has no legs to stand on, I have seen that those attachments are blindly confirmed by the adjudicating authority. Now, what happens after your attachment is confirmed? Your recourse is to file an appeal before the tribunal. Your then matter reaches the tribunal decides the issue. Assuming it is decided against you, you have a right to appeal before the High Court, where your ED is based. The ED which has issued the attachment will be the situs of the AO. From that, you will have to see the territorial jurisdiction of the High Court and file your appeal. And final appeal goes to the Supreme Court after that. So that is the civil side of it. Coming to the criminal side of it, the criminal side is your criminal prosecution, where again a criminal complaint is filed before the criminal special court and your trial is undertaken to see and decide whether you are guilty of proceeds of crime of money or money laundering under section 3 or not. Now again, I briefly gave you a legal standpoint of steps undertaken for attachment. But what happens during an attachment? What are the safeguards provided under law? How is an attachment done? What are the jurisdictional conditions for an attachment to be made under section 5, etc., are given under section 5, which I will read and explain it. Section 5, attachment of property involved in money laundering, where the director or any other officer not below the rank of deputy director authorized by the director for the purposes of this section has reason to believe, the reason for such belief to be recorded in writing, that any person is in possession of proceeds of crime. Now kindly note, this uses the term any person. So I may have committed money laundering and taken that money, but I have given it to B, B has given it to C, C has given it to D. Today D has that money. So D is in possession of proceeds of crime, sir. D will be that any person as mentioned in subsection 5 subclause A. So any person is in possession of crime, and number 2, such proceeds of crime are likely to be concealed, transferred or dealt with in any manner which may result in frustrating any proceedings relating to the confiscation of such proceeds of crime. Then he may by an order provisionally attach such property but not exceeding 180 days from the date of the manner order. So in other words, property of any person can be attached. This attachment is done so that that property cannot be squandered away. But in practice, this action, this extraordinary power of attachment is done on a very mechanical level. Now 5 subclause 2, after the attachment is made, the director or any other officer not below the rank of deputy director shall immediately after attachment under subsection 1 forward a copy of the order along with the material in his possession referred to in the subsection to the adjudicating authority in a sealed envelope in such manner as may be prescribed, and the adjudicating authority shall keep such order and material for such period as may be prescribed. So attachment done under 1, then the ED, the deputy director, or as the case may be, whichever authorized officer is there, he may forward a copy of the order along with the material in a sealed envelope to the adjudicating authority. Clause 3. Every order of attachment shall cease to have effect after the expiry of the period mentioned in that subsection, which is 180 days. That means that attachment is only valid for a period of 180 days. After a period of 180 days, the attachment will automatically lapse. Therefore, if the adjudicating authority does not pass an order confirming or rejecting that provisional attachment order within the period of 180 days, that provisional attachment order will lapse, and nor will that attachment order liable to be continued or confirmed. So this is a very important section, and this issue is currently pending before the Honorable Supreme Court in the case of Vikas WSP, where the question of law is as to whether after 180 days the provisional attachment order ceases or remains. The courts have decided that it will expire. The high courts have decided that it will expire after the 180 day, but the department is challenging the same before the Supreme Court. Now, subclause 4. Nothing in this section shall prevent the person interested in the enjoyment of the immovable property attached under section 1 from such enjoyment. For the now, until the property is attached, you can enjoy the property. Subsection 5, he files a complaint giving to the adjudicating authority, giving all the reasons of attachment. Now, this is the first power. First, civil power. What is the second civil power? The second civil power given to the ED is of survey, search, and seizure under section 16 to 18. In these sections, they can conduct a search, they can conduct a survey under section 16, they can conduct a search under section 17. In a search, they may even seize any record or property found as a result of search. They may examine you on oath. They may pass an order freezing such property and proceed further. They may also conduct a search of person, which is done under section 18, that when any person has secreted about his person or anything under his possession, ownership, or control, then that search may be conducted under section 18. Now, attachment under section 5, freezing order under section 17(1)(a, or a confiscation under section 20, its adjudication will be done by the adjudicating authority under section 8. The adjudicating authority has to first record its reasons that a person may have committed a scheduled offense or is in proceeds of crime. After recording its reasons, it will serve a notice of less than 30 days, seeking the sources of income, earning, or assets by way of which that person whose property has been attached, asking him the source and the manner in which he has acquired the property, or any other relevant information. After receiving the notice, we file our reply. The adjudicating authority then, after considering our reply and hearing us in person, will then pass an order as deciding as to whether that property is live, the property so attached, and said such attachment is liable to be confirmed or not. Now, when the provisional attachment order has been confirmed, then the director or any other person shall take possession of the property attached under section 5 or under section 17 as the case may be. But now courts have decided that confiscation should not be done immediately. When your attachment has been confirmed, the property cannot be transferred. You are well within your right to just let the property be. So you can only confiscate the property once the special court has held that yes, Mr. X has committed money laundering and all these assets are in relation to money laundering. When that is done, only then can such property be confiscated. The other thing is that if the special court also finds that the offense of money laundering has not taken place, it shall release such property to the person entitled to receive it. Now, your attachment can be done, your search and seizures will be done, your confiscation, your confirmation will be done by the adjudicating authority. Your prosecution will be undertaken by the criminal court. And wide powers are available. The law is very widely worded. On top of that, what makes the PMLA even more difficult or a draconian law is that there is a reverse burden of proof. In other words, it is not the ED who has to prove that the money laundering has been done, or proceeds of crime are involved in money laundering. It is not the duty of the ED to show it. Rather, there is a presumption under law that it will be presumed that proceeds of crime are involved in money laundering, sir. And the person who is charged with money laundering or whose property has been attached, he has to dispel such presumption. Therefore, there is a reverse burden of proof on me. When the case will start, they will presume I have done everything wrong. I have to disempower and disimpel that presumption by putting cogent evidence. So this reverse burden of proof, as is there under the PMLA and even in other acts such as the Narcotropics, Psychotropic Substances Act and other laws, are very integral. It's a very draconian provision which makes the case even highly burdensome and puts us at a very position of putting an extra foot forward in these cases. Now, assuming your property was attached and that attachment has been confirmed by the adjudicating authority, what will you do now? You have the right to appeal to the tribunal. So, any person who is aggrieved by any order, he may approach and prefer an appeal before the tribunal. This appeal has to be filed within a period of 45 days from the date on which the copy of the order is received. And a fee of 10,000 rupees as appeal fee has to be paid, so on and so forth. We also hear a lot of arrests happening. In these arrests, I was fortunate enough to work with Mr. Zohaib Hussain that time, the front man, the front lawyer for ED. And while assisting him and while working with the ED during that tenure, we worked on matters such as Mr. Arvind Kejriwal's matter, Mr. Manish Sisodia's matter. And you all have heard about arrests and bails. We all heard, how is this happening? How is a sitting chief minister? How are such high level people who have all the power, the money, the wealth, everything, the connections? How are such people now being put behind bars? And even when put behind bars, their bails were rejected. So, why was that happening? One may think. So, it is necessary to note that the threshold of bail under a normal criminal law, under a normal, let's say, even a murder case, is very different. In a normal criminal case, you will have to prove before the court that this trial will take a lot of time. Whether I'm guilty or I'm innocent has to be decided at the end of the trial. I have my roots here in the vicinity. My family stays here. I'm the sole bread earning member of the family. So and so people are dependent upon me. I will not tamper with the evidence. I will not influence the witnesses. And when I satisfy the court regarding all those aspects, in a normal criminal case, a bail might be granted to me depending on circumstances. But the threshold of seeking bail under the PMLA is very different. Now you may read with me, it's given in section 45. It starts with a notwithstanding clause, notwithstanding anything contained in the Code of Criminal Procedure 1973. मतलब जो normal ordinary principle लगता है for normal criminal bails in normal criminal matters will not apply, notwithstanding, not considering anything in the CRPC. No person accused of an offense shall be released on bail or on his own bond unless the public prosecutor has been given an opportunity to oppose the bail. पब्लिक प्रोसिक्यूटर साहब को जब तक अपॉर्चुनिटी नहीं मिलती तब तक आपकी बेल की सुनवाई होएगी नहीं. In other words, in a lot of times, the public prosecutor keeps taking dates so that your bail may get postponed. This is the number one thing. Number two, where the public prosecutor opposes the application of bail, the court has to be satisfied that there are reasonable grounds for believing that the person who is seeking bail is not guilty of the offense and is not likely to commit any offense while on bail. Matlab, at the stage of bail, to seek bail in a PMLA matter, we will have to prove that we are not guilty of the offense of PMLA. In other words, the matter which has to be decided at the fag end, we have to show that during bail that we are not guilty. Only then can bail be granted to us under the PMLA. Now, these twin conditions were held to be unconstitutional in the judgment in 2018. As soon as that judgment was passed, that judgment held that, sir, what is the purpose of a trial if you have to decide during bail whether that person is guilty or not guilty? So the court held, as Justice Nariman that time held, that these conditions are ultra vires and non constitutional, and therefore they struck down these two conditions. As soon as the order came, within 1 month, Justice Nariman was retired. Within the second month, or I think even a month, 15 days, a month and a half, an amendment was brought into this act again, bringing back the twin conditions again, which shows the manner in which the government is acting or the government wants to act without considering or without allowing any law to reach finality. Having said that, these conditions as they stand today, valid in the eyes of law, are very onerous, very burdensome conditions which have to be met by any person who has been arrested and is accused of money laundering. Now, under income tax, under GST, under other laws, a lot of statements are recorded when searches are conducted. Those searches, those statements, unless corroborated by evidence, unless corroborated by material, have no value because those are mere statements. And those statements, unless cross examination of those people are given, those statements have no value. To the contrary, a statement given to the ED under Section 15 is a statement under oath. It is a statement which is sufficient, and even the courts are considering them sufficient enough to impose grave liability and are acting solely on the basis of the said statements. Therefore, the role of these statements becomes very big and deep. This is the manner in which the ED today is conducting its proceedings. And this is the brief overview of the Act. Now, coming to the second aspect of it, what is the role of a CA in PMLA proceedings? Now, sir, a chartered accountant, and the difference between a lawyer, if I may say so, is a chartered accountant will be there to finalize the books, to complete the audit, to show and reflect in its audit a true correct state of affairs. And on that basis of that audit, you file your return. So the role of a chartered accountant comes prior to any declaration. The role of an advocate is a little different. You go to a lawyer when you are in a soup already, when an action has been taken against you. Why am I giving this difference? Because in a lot many seminars where I have been asked by people that why is there a difference between an advocate and a CA? So before coming into the role of a CA in PMLA proceedings, I would just like to show you and tell you and remind you that the role of a CA is ex facto before any act is committed, before a company takes its loans from the bank, and if they cheat the bank, it's a scheduled offense. ED will ask the bank will say that I gave the loan on the basis of these financial statements. ED will then say that those financial statements have been inflated. Now, who signed the financial statements? The chartered accountant. Who will be roped in? The chartered accountant. That, sir, why did you inflate this asset and show its value different? Why did you inflate the stocks? Why did you do that? Why did you do that? Therefore, you have actively participated and rather allowed Mr. X to get this loan, which he never had any idea to use, but only wanted to squander of that loan for his own benefit. So you are a very integral party in this, and therefore you, Mr. Chartered Accountant, are also an accused under the PMLA. One may note the case of Bhushan Steel and BPCL Power. In those cases, very big chartered accountants are today behind bar. They are behind bars. Now, the reason in those cases, that time I worked on those cases from the side of the ED, and we managed to get a cancellation, to get a rejection of their bail. And it was only because we could show all these aspects which the court also considers. Because your role is not to be an accomplice, but to act as an independent auditor and give the correct, true reflection of the books. That is your number one role. Your second role comes that under the reporting authority. Last year, there was great hue and cry regarding chartered accountants being brought within the realm of being made a reporting entity. Now, who is a reporting entity? A reporting entity under the PMLA is the person or a professional who specifically performs certain financial transactions for your clients. For example, if you keep client identities, you carry on his business, you are opening his different entities for them, you are opening, let's say, managing their assets, you are buying and selling immovable property, you are managing their money security or assets, you are managing their bank account, you are organizing their contributions, or you are creating companies on their behalf, LLPs or trust or XYZ, and buying and selling businesses on their behalf. Then, as per section 21WA of the PMLA, you become a reporting entity. In case of a reporting entity, what you have to do is you have a liability to report to the ED every year certain information. And in case you fail to do that, there are punishments which are imposed under the PMLA, which is not arrest, which is not criminal punishment, but only pecuniary punishment of up to 10 lakh rupees, between 1 and 10 lakh rupees, starting from 10,000 actually, in different things. So, from a legal standpoint, those notifications are not to worry about. But when you sign an audit or when you get a loan for your client, in all those aspects, You have to be prepared that, sir, when you're signing that papers and showing certain things, your audit is independent under the eyes of law and it should be independent. If they find that because of your inflation they could get that money, they will rope you in. Number one. So we have to be very vigilant as chartered accountants to not fall within that criteria. And within now, with the change of technology and with the advent of technology, there is so much information with them that you cannot even imagine. While working with the ED, I understood the wide domain of information which they have, and it's not even funny. Now, coming to the second aspect. So, I initially said when you yourself are in trouble and by under the PMLA, this was that condition. Number two, when your client is now under the scrutiny of ED, then what can you do as a chartered accountant? Now, sir, PMLA is a very legal law. I will say that. Unlike income tax, unlike GST, unlike other laws, especially these two, income tax and GST, which is technically very related to your own practice, teachings, which were taught to you while becoming a CA. All those aspects are there in the Income Tax Act, in the GST. That is why Income Tax Act becomes an easy topic for for chartered accountants to work on. And for us lawyers, it becomes a little hard. We have to learn all those things which you already know. However, for PMLA, the law and the training that is required is more on the legal side. You have to know what can be the sanctity of a statement. Till what extent can a statement be used? Till what extent a power under 8.4 can be exercised by the special authority? If you have to file before the special authority, you will, as a CA, not be able to file. So, what I suggest, and very big chartered accountants in the country who work with me on these matters, who are my briefing counsels, their valuable advice is something I cannot even mention, because how you understand numbers, nobody can understand numbers as well as a chartered accountant. So it is always better to team up with a lawyer at that time if there is even an attachment or a criminal matter. Criminal matter anyway you will not be able to, but you can appear before the adjudicating authority and you can appear before the tribunal. There is no bar. However, the law and the application and the practicality of that application of that law is more on the legal side, for which one, I believe, requires certain legal assistance and experience and learnings. So, having said that, this in sum and substance was the PMLA and the role of PMLA when he himself is entrapped or when his client is entrapped. For any further questions or clarifications, I'll be pleased to answer the queries. Ratnaveel sir, handing over to you, sir, please.
பாஸ் நல்லா இருக்கும் இது நாகர்கோவில் நாகர்கோவில் நல்லா இருக்கும் அதுதான் அது மக்களே
Ratnaveel sir, hello. If anybody has any questions or queries, I'll be free to. Upender sir, you can unmute yourself, sir, please. So query has been put by a very senior chartered accountant, sir, in Delhi, Mr. Upendra Taneja. Section 420 will always attract PMLA action. Always, no, sir, but it is a scheduled offense. I will just show it to you in a second. So, under PMLA, these are the schedules. This is the schedule, part A, section 120B, so and so, all sections are there. 420 is also a scheduled offense. So, ED is well within their right to initiate action, but to do or not to do is their own prerogative. And most likely they do it when the stakes are big, and when the matters are more than a crore, and likewise, then they undertake such an action. Ramakrishnan sir, over to you. My deliberations are done. If there are any queries, anybody can ask. Otherwise, I would like to leave.
So there is another question, like as per section 12 of PMLA Act, only banks and financial institutions should report every year. Is there any obligation for the chartered accountant to report every year?
No, sir, not in general. But last year, Section 2WA of the PMLA defines who is a reporting entity. Under Section 2WA, last year, a notification was issued which included the chartered accountants, the cost accountants under under the section as a reporting entity. Now, not all chartered accountants are reporting entities. You may see section 1SA, which includes specific things which you need to do to become a reporting entity. If you're normally just signing an audit, if you're normally just preparing books for a client, if you're doing the other activities, you are not a reporting entity. But if you read section 21SA, read with section 21WA, you will see that there are certain criteria, certain transactions. If you buy or sell property on behalf of your client, if you manage your client's money, securities, or assets, if you maintain your client's bank account, savings, or securities accounts, if you maintain, operate, or manage their companies, if you buy, sell companies, trust, firms, etc. on their behalf, if you do these transactions, then you become a reporting entity. Then you are doing a specific designated business or profession to have been included as a reporting entity. But a CA in general parlance is not a simpliciter reporting entity under the ED. Please, any other questions? If no, then I would just like to thank everybody for taking out their time, and most importantly, thanking SIRC and its esteemed members for giving me the opportunity to deliberate on this issue. And with that, I would like to take your leave, and thank you so much, everyone. Thank you.